If you're applying for H1B, OPT, green card or any other immigration benefit in the US, there is an important new update from USCIS. Earlier, if some important evidence was missing from an application, USCIS could send an RFE, request for evidence, and give the applicant another chance to submit the documents. But now, it should not depend on getting an RFE. USCIS officers can directly deny some applications if the required evidence is missing or if the applicant has not shown that they are eligible. Let us understand what exactly has changed. On August 5th, 2026, USCIS announced a new policy regarding immigration applications and petitions. USCIS says applicants must submit enough evidence to prove their eligibility when they file the application. If important required evidence is missing, USCIS officers may deny the application without first sending an RFE. They may also deny a case without first sending a notice of intent to deny, also called a NOID. Your first submission needs to be as complete as possible. Does this mean there will be no more RFEs? No. This is where people should be careful about information circulating on social media. USCIS has not stopped issuing RFEs. USCIS officers can still send an RFE if they need additional information. But the difference is this: applicants should not assume that USCIS will always send an RFE before denying their case. In some cases, if important evidence is missing, USCIS may directly deny the application. So an RFE should not be treated as guaranteed second chance. What does this mean for H1B? Now let us talk about H1B applicants. When an employer files an H1B petition, they normally submit several supporting documents. This can include information about the job, the employee's education and experience, the employer, and other documents supporting H1B eligibility. If important required evidence is missing, employers should not assume USCIS will simply send an RFE and allow them to fix the problem. USCIS may have the discretion to deny the petition based on the documents already submitted. So, employers and applicants need to be more careful when preparing the initial H1B filing. What about OPT students? This is also important for international students applying for OPT. Students filing Form I-765 for employment authorization should carefully check the latest USCIS instructions. Make sure all required documents and evidence are included before submitting the application. Don't think if something is missing, USCIS will send me an RFE and I can submit it later. Under the new policy, depending on the circumstances, that opportunity may not always be available. What about cases already filed? Another important question is, what happens if your application is already pending with USCIS? According to USCIS, this policy became effective immediately on August 5th, 2026, and it applies to immigration benefit requests that are pending or filed on or after August 5th unless another regulation or USCIS policy says otherwise. So even people already who have applications pending should understand this change. So what should H1B employees, international students, employers and green card applicants learn from this? The message is simple. Do not file an incomplete application thinking you can provide the remaining documents after receiving an RFE. Check the latest USCIS requirements. Make sure all required evidence is included. Double check your application before filing. And for complicated immigration cases, consider getting advice from a qualified immigration attorney. Remember, USCIS has not stopped RFEs, but an RFE is not something applicants should automatically expect before a denial. So going forward, getting the application right the first time becomes even more important. Follow Nuthan Frames for more updates about US immigration, jobs, technology, and opportunities.